Question 1. Examination of the data shows that an applicant is seeking a Category H firearms license in Tasmania. Which of the following approaches best demonstrates compliance with the requirements of the Firearms Act 1996, Tasmania, and its associated regulations for obtaining such a license? Option A. Presenting a previous firearms license from another Australian state as sufficient proof of eligibility for a Tasmanian Category H license, without providing specific Tasmanian compliant documentation. Option B. Providing a detailed written submission outlining a genuine reason for possessing a Category H firearm, supported by comprehensive evidence of suitability, including character references, proof of relevant training, and a clear plan for secure storage, all tailored to meet the specific criteria of Tasmanian law. Option C. Submitting a brief application form with a verbal assurance of a genuine reason for ownership and a general statement about safe storage practices. Option D. Focusing solely on demonstrating technical proficiency with a Category H firearm, assuming this inherently satisfies the genuine reason and suitability requirements. Correct answer is B. Providing a detailed written submission outlining a genuine reason for possessing a Category H firearm, supported by comprehensive evidence of suitability, including character references, proof of relevant training, and a clear plan for secure storage, all tailored to meet the specific criteria of Tasmanian law. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to demonstrate not only an understanding of the legal requirements for a Category H firearms license in Tasmania, but also the ethical consideration surrounding the responsible ownership and use of firearms. The challenge lies in accurately identifying the most comprehensive and legally sound approach to satisfying the licensing criteria, particularly concerning the genuine reason and suitability requirements, which are subject to interpretation and require thorough evidence. Correct approach analysis. The best professional practice involves a comprehensive and proactive approach to gathering and presenting all required documentation and information. This includes clearly articulating a genuine reason for possessing a Category H firearm that aligns with the provisions of the Firearms Act 1996, Tasmania, and its associated regulations. It necessitates providing detailed evidence of suitability, such as references, training certificates, and a clear explanation of safe storage arrangements, all of which directly address the requirements outlined in Section 35 of the Act concerning the applicant's character and fitness. This approach ensures all statutory obligations are met with robust supporting evidence, minimizing ambiguity, and demonstrating a commitment to responsible firearm ownership as mandated by Tasmanian law. Incorrect approaches analysis. One incorrect approach involves submitting minimal documentation and relying solely on a verbal explanation of a genuine reason. This fails to meet the evidentiary requirements of the Firearms Act 1996, Tasmania, which mandates written evidence for genuine reasons and suitability. It leaves too much to the discretion of the licensing authority and does not demonstrate the applicant's commitment to providing a thorough and transparent application. Another incorrect approach is to focus only on the technical aspects of firearm ownership, such as proficiency with a particular firearm, without adequately addressing the genuine reason or suitability criteria. While firearm proficiency is important, it does not, in isolation, satisfy the broader requirements of the Act, which also considers the applicant's character, associations, and the specific purpose for which the firearm is sought. A further incorrect approach is to assume that a previous firearms license in another jurisdiction automatically qualifies an applicant in Tasmania without providing specific Tasmanian compliant documentation. Each jurisdiction has its own legislative framework, and an applicant must demonstrate they meet the specific requirements of the Firearms Act 1996, Tasmania, including providing Tasmanian-specific references and evidence of safe storage within the state. Professional reasoning. Professionals should adopt a systematic approach to licensing applications. This involves thoroughly reviewing the specific legislative requirements of the relevant jurisdiction, in this case, the Firearms Act 1996, Tasmania, and its regulations. They should then gather all necessary supporting documentation, ensuring it directly addresses each criterion. Proactive communication with the licensing authority to clarify any ambiguities and presenting a comprehensive, well-supported application are crucial for a successful outcome and demonstrate professional diligence and adherence to legal and ethical standards. Question 2. Upon reviewing the requirements for a Category H firearms license in Tasmania, an applicant is preparing their application. Which of the following approaches best demonstrates an understanding of the legislative framework and ethical responsibilities associated with firearm ownership in Tasmania? Option A. Clearly articulating a specific, verifiable, genuine reason for possessing the firearm, supported by evidence of safe storage plans and an understanding of relevant safety regulations, and completing all application forms accurately and truthfully. Option B. Completing all sections of the application form with the minimum required information, assuming that a stated interest in firearms is sufficient to satisfy the licensing authority. Option C. Focusing on the administrative aspects of the application, such as ensuring all fees are paid, and believing that a general desire to own a firearm for personal protection is a universally accepted genuine reason in Tasmania. Option D. Providing a brief, general statement about an interest in firearms, and assuming that the licensing authority will conduct its own investigations to determine suitability and genuine reason. The correct answer is A. Clearly articulating a specific, verifiable, genuine reason for possessing the firearm, supported by evidence of safe storage plans and an understanding of relevant safety regulations, and completing all application forms accurately and truthfully. Explanation. This scenario presents a professional challenge because it requires an applicant to demonstrate not only an understanding of the legal requirements for a Category H firearms license in Tasmania, but also the ethical considerations and practical implications of firearm ownership. The applicant must navigate the specific provisions of the Firearms Act 1996, TAS, and associated regulations, which mandate a genuine reason for possessing a firearm and a thorough assessment of the applicant's suitability. The difficulty lies in balancing the applicant's stated desire with the stringent safety and public interest considerations inherent in firearms licensing. The best approach involves a comprehensive and honest self-assessment that directly addresses the genuine reason requirement and proactively provides evidence of suitability. This includes clearly articulating the specific purpose for which the firearm is sought, such as participation in a recognized sport or occupational necessity, and demonstrating an understanding of safe storage and handling practices. This approach aligns with the spirit and letter of the Firearms Act 1996, TAS, which requires applicants to satisfy the Registrar of Firearms of their genuine reason and fitness to possess a firearm. It demonstrates a commitment to responsible firearm ownership and a proactive engagement with the licensing process, thereby increasing the likelihood of a successful application by meeting all statutory obligations. An approach that focuses solely on the administrative completion of forms without a deep understanding of the underlying requirements is professionally deficient. This fails to acknowledge that the licensing authority must be satisfied of a genuine reason, not merely that a reason has been stated. It overlooks the critical need to provide supporting evidence and demonstrate an understanding of safe practices, which are fundamental to public safety and the integrity of the licensing system. Another unacceptable approach is to assume that a past or general interest in firearms is sufficient without a specific, current, and demonstrable genuine reason. The legislation requires a concrete purpose for the license, not a vague or historical inclination. This approach risks misrepresenting the applicant's intentions and failing to meet the statutory threshold for genuine reason. Finally, an approach that prioritizes obtaining the license above all else, potentially by downplaying or omitting relevant personal history or safety concerns, is ethically and legally unsound. This undermines the licensing authority's ability to conduct a thorough risk assessment and jeopardizes public safety. It also contravenes the applicant's obligation to provide truthful and complete information. Professionals should adopt a decision-making process that prioritizes understanding the specific legislative requirements of Tasmania's Firearms Act 1996, including the definition and demonstration of a genuine reason. This involves researching the relevant sections of the Act and any accompanying regulations or policy guidelines issued by the Tasmanian Police. Subsequently, they should critically evaluate the applicant's circumstances against these requirements, focusing on gathering evidence that directly supports the stated genuine reason and demonstrates the applicant's commitment to safe and responsible firearm ownership. This proactive and evidence-based approach ensures compliance and promotes ethical conduct. Question 3. When evaluating an application for a Category H firearms license in Tasmania, what is the most effective approach for an applicant to demonstrate they meet the requirements of the Firearms Act 1996, Tasmania, particularly concerning the genuine reason for possession and the applicant's suitability? Option A. The applicant should focus solely on proving their identity and residency in Tasmania, believing that these factors alone will satisfy the licensing authority regarding their suitability. Option B. The applicant should provide detailed documentation outlining their specific genuine reason, e.g., membership in an approved sporting club with details of intended use, and comprehensive evidence of proposed safe storage arrangements that comply with Tasmanian regulations. Option C. The applicant should submit a brief statement indicating their desire to engage in sporting activities and express their intention to store the firearm securely without providing specific details. Option D. The applicant should rely on a previous firearms license obtained in another Australian state, assuming it will be sufficient without providing additional Tasmanian-specific documentation. Correct answer is B. The applicant should provide detailed documentation outlining their specific genuine reason, e.g., membership in an approved sporting club with details of intended use, and comprehensive evidence of proposed safe storage arrangements that comply with Tasmanian regulations. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to demonstrate not only a genuine reason for possessing a firearm, but also to satisfy the licensing authority that they are a fit and proper person, considering their past conduct. The onus is on the applicant to provide sufficient evidence, and the Tasmania Police, as the issuing authority, must exercise due diligence in assessing this evidence against the requirements of the Firearms Act 1996, Tasmania. The challenge lies in balancing the individual's right to apply for a license with the public safety imperative. Correct approach analysis. The best professional approach involves the applicant proactively and comprehensively providing all requested documentation and information that directly addresses the genuine reason for needing a firearm and demonstrates their suitability. This includes clear evidence of membership in an approved club or organization for sporting purposes, along with a detailed explanation of how the firearm will be used within that context. Furthermore, the applicant must provide evidence of safe storage arrangements that comply with the Act and regulations, and be prepared to undergo any necessary interviews or assessments. This approach is correct because it directly aligns with the requirements of Section 38 of the Firearms Act 1996, Tasmania, which mandates that an applicant must satisfy the registrar that they have a genuine reason for possessing a firearm and are a fit and proper person. By providing thorough and relevant documentation upfront, the applicant facilitates a fair and efficient assessment process, demonstrating their commitment to compliance and responsible firearm ownership. Incorrect approaches analysis. One incorrect approach is to provide vague or incomplete information regarding the genuine reason, such as simply stating sporting purposes, without specifying the type of sport or the relevant club. This fails to satisfy the requirement for a clearly articulated genuine reason under Section 38 of the Act, and leaves the registrar with insufficient information to make an informed decision, potentially leading to refusal. Another incorrect approach is to neglect to provide any details about proposed safe storage arrangements. The Firearms Act 1996, Tasmania, and its associated regulations place significant emphasis on the secure storage of firearms to prevent unauthorized access. Failure to address this critical aspect demonstrates a lack of understanding of, or commitment to, the legal requirements for firearm ownership, and would be a direct contravention of storage provisions. A further incorrect approach is to assume that a previous license in another state or territory automatically qualifies the applicant without providing specific Tasmanian-compliant documentation or addressing any potential differences in requirements. While prior licensing may be a factor, the registrar in Tasmania must be satisfied based on the evidence presented in accordance with Tasmanian law. This approach risks overlooking specific Tasmanian legislative requirements and may lead to an incomplete application. Professional reasoning. Professionals should adopt a proactive and transparent approach when applying for or assessing firearm licenses. This involves thoroughly understanding the specific legislative requirements of the jurisdiction. In this case, Tasmania's Firearms Act 1996 and associated regulations, gathering all necessary supporting documentation, and clearly articulating how the application meets each criterion. When assessing an application, professionals must rigorously check for compliance with all statutory requirements, paying particular attention to the genuine reason, the applicant's suitability, and safe storage provisions. If any aspect is unclear or incomplete, further information should be sought before making a determination. Question 4. The analysis reveals that an applicant for a Category H firearms license in Tasmania has a documented history of a significant mental health condition. In assessing their suitability, what is the most professionally sound and legally compliant course of action? Option A. Accept the applicant's verbal assurance that they have fully recovered and no longer experience any issues related to their past mental health condition. Option B. Request a letter from a close friend or family member attesting to the applicant's current mental well-being. Option C. Reject the application immediately based on the past diagnosis, without further investigation into their current mental state or treatment. Option D. Obtain detailed, current medical reports from the applicant's treating medical practitioners, specifically addressing their mental health status, treatment adherence, and prognosis, to inform the assessment of their fitness and propriety. The correct answer is D. Obtain detailed, current medical reports from the applicant's treating medical practitioners, specifically addressing their mental health status, treatment adherence, and prognosis, to inform the assessment of their fitness and propriety. Explanation. The analysis reveals a scenario where an applicant for a Category H firearms license in Tasmania has a history of mental health challenges. This presents a professional challenge due to the inherent public safety risks associated with firearms and the legal obligation under Tasmanian law to ensure that license holders are fit and proper persons. The assessment requires a delicate balance between an individual's right to apply for a license and the paramount importance of community safety, necessitating a thorough and objective evaluation of the applicant's current mental state and its potential impact on their ability to safely possess and use a firearm. The best approach involves a comprehensive assessment that prioritizes objective evidence and expert opinion. This includes obtaining detailed medical reports from the applicant's treating medical practitioners, specifically addressing their current mental health status, treatment adherence, and prognosis regarding any conditions that could impair judgment or impulse control. This approach is correct because it directly aligns with the requirements of the Firearms Act 1996, Tasmania, and associated regulations, which mandate that the Commissioner of Police must be satisfied that an applicant is a fit and proper person, taking into account factors such as mental health. Relying on current, expert medical advice ensures the decision is informed, evidence-based, and prioritizes public safety as mandated by law. An incorrect approach would be to solely rely on the applicant's self-declaration of being over it, without seeking independent medical verification. This fails to meet the evidentiary standards required by Tasmanian firearms legislation, which necessitates more than mere assertion. It creates a significant regulatory failure by not adequately assessing the risk to public safety. Another incorrect approach would be to dismiss the application outright based solely on the past diagnosis without considering current medical assessments and treatment outcomes. This could be considered an ethical failure, as it may unfairly penalize an individual who has successfully managed their condition and poses no current risk, potentially contravening principles of fairness and rehabilitation. Finally, accepting a letter from a friend stating the applicant is fine is entirely insufficient and represents a severe regulatory and ethical lapse, as it lacks any professional credibility or objective assessment of risk. Professionals should adopt a structured decision-making process that begins with identifying the core legal and ethical obligations. This involves understanding the specific requirements of the Tasmanian Firearms Act 1996 regarding fit and proper persons and mental health. The process should then focus on gathering all relevant, objective evidence, particularly from qualified medical professionals. A risk-based assessment framework should be applied, weighing the potential risks against the evidence of the applicant's current capacity and stability. Transparency and fairness should be maintained throughout the process, ensuring the applicant is aware of the information being considered and has an opportunity to provide further relevant details. Question 5. Comparative studies suggest that in Tasmania, when a customer wishes to purchase a Category H firearm from a licensed dealer, What is the most legally sound and professionally responsible initial action for the dealer to take? Option A. Immediately refuse the sale without allowing the customer to present any form of license documentation. Option B. Accept the customer's verbal assurance that they possess a valid Category H firearms license and proceed with the sale. Option C. Sell the firearm to the customer and instruct them to obtain the appropriate license within 48 hours of the purchase. Option D. Request to see the customer's current and valid Category H firearms license and verify its details against the firearm being purchased. The correct answer is D. Request to see the customer's current and valid Category H firearms license and verify its details against the firearm being purchased. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in Tasmania when faced with a customer seeking to acquire a Category H firearm. The core challenge lies in balancing the customer's request with the stringent legal requirements for firearm ownership and licensing in Tasmania, specifically under the Firearms Act 1996, TAS. Failure to adhere to these regulations can result in severe penalties, including fines, license suspension or cancellation, and criminal charges. Professional judgment is required to ensure all legal obligations are met without undue delay or unnecessary obstruction to a legitimate applicant. Correct approach analysis. The best professional practice involves meticulously verifying the customer's Category H firearms license and ensuring it is current and valid for the specific type of firearm being sought. This approach directly aligns with Section 36 of the Firearms Act 1996, TAS, which mandates that a dealer must not sell or transfer a firearm to a person unless that person produces a valid license authorizing them to possess that class of firearm. The dealer must also record the transaction details as required by the Act. This ensures compliance with the law, promotes public safety by preventing unauthorized firearm acquisition, and maintains the integrity of the firearms registry. Incorrect approaches analysis. One incorrect approach is to assume the customer's stated license status is sufficient and proceed with the sale based on their word alone. This fails to meet the explicit legal requirement of producing a valid license for verification, as stipulated in Section 36 of the Firearms Act 1996, TAS. Ethically, it bypasses a crucial safety check designed to prevent firearms from falling into the wrong hands. Another incorrect approach is to sell the firearm and inform the customer that they must obtain the necessary license within a short time frame after the purchase. This is a direct contravention of Section 36 of the Firearms Act 1996, TAS, which requires the license to be presented * before * the sale or transfer. It places the onus of compliance on the customer after the fact, which is legally impermissible and ethically irresponsible. A further incorrect approach is to refuse the sale outright without allowing the customer to present their license for verification. While caution is necessary, an outright refusal without following the prescribed verification process can be seen as an unreasonable impediment to a legitimate transaction if the customer subsequently produces a valid license. The law requires verification, not an arbitrary denial of service. Professional reasoning. Professionals in Tasmania dealing with firearms transactions must adopt a systematic and legally compliant approach. This involves understanding and strictly adhering to the provisions of the Firearms Act 1996, TAS. The decision-making process should prioritize legal compliance and public safety. When presented with a customer seeking to purchase a firearm, the immediate step is to request and verify the relevant license. If the license is valid and appropriate for the firearm, the transaction can proceed with all required record keeping. If the license is invalid, expired, or not appropriate, the sale must be refused, and the customer advised on the correct procedure to obtain a valid license. This structured approach ensures both legal adherence and responsible conduct. Question 6. The investigation demonstrates that a Category H firearms license applicant in Tasmania has a documented history of voluntary hospitalization for depression. Considering the requirements of the Firearms Act 1996, Tasmania, which of the following represents the most appropriate course of action for the licensing authority? Option A. Grant the license immediately based on the applicant's self-declaration of recovery without seeking further medical information. Option B. Automatically refuse the license application due to the applicant's past voluntary hospitalization for depression. Option C. Grant the license with a minimal condition of a 6-month review period without obtaining detailed medical assessments. Option D. Obtain comprehensive medical reports from the applicant's treating practitioners to assess their current mental state and fitness to possess a Category H firearm. The correct answer is D. Obtain comprehensive medical reports from the applicant's treating practitioners to assess their current mental state and fitness to possess a Category H firearm. Explanation. The investigation demonstrates a scenario where a Category H firearms license applicant in Tasmania has disclosed a history of mental health challenges, including a period of voluntary hospitalization for depression. This presents a professionally challenging situation for the licensing authority, requiring a delicate balance between public safety and an individual's right to possess firearms, while adhering strictly to the Firearms Act 1996, Tasmania, and associated regulations. The core challenge lies in assessing the applicant's current fitness and the potential risk they may pose, given their past mental health issues. The best approach involves a thorough, evidence-based assessment of the applicant's current mental state and the potential for relapse or risk. This includes obtaining comprehensive medical reports from treating practitioners, detailing the nature of the mental health condition, the treatment received, the applicant's response to treatment, and a professional opinion on their current fitness to possess a Category H firearm without posing a danger to themselves or others. This approach is correct because it directly aligns with the principles of the Firearms Act 1996, Tasmania, which mandates that a person must be a fit and proper person to hold a license, and that the authority must consider any risk to public safety. Section 36 of the Act specifically allows for the refusal of a license if the applicant is not a fit and proper person, which includes considerations of mental health that could impact safety. Ethical considerations also demand a fair and objective assessment based on current evidence, rather than solely on past events. An incorrect approach would be to automatically refuse the license based solely on the past voluntary hospitalization. This fails to acknowledge that mental health conditions can be managed and that individuals can recover and be fit to hold a license. It contravenes the principle of assessing current fitness and could be seen as discriminatory. Another incorrect approach would be to grant the license without seeking any further medical information, relying only on the applicant's self-declaration of recovery. This would be a significant regulatory failure, as it bypasses the due diligence required by the Firearms Act 1996, Tasmania, to ensure public safety and the applicant's fitness. It neglects the responsibility to gather sufficient evidence to make an informed decision. A further incorrect approach would be to grant the license with minimal conditions, such as a short review period, without a comprehensive understanding of the applicant's condition and treatment. This might not adequately mitigate any potential risks and could be seen as an insufficient application of the licensing authority's duty of care. Professionals should employ a decision-making framework that prioritizes evidence gathering, objective assessment, and adherence to legislative requirements. This involves understanding the specific criteria for fitness and properness under the Firearms Act 1996, Tasmania, consulting with medical professionals when necessary, and making decisions that demonstrably protect public safety while being fair to the applicant. The process should be transparent and documented, ensuring that all decisions are justifiable and defensible. Question 7. Analysis of a Category H firearms license holder in Tasmania who has recently been subject to a domestic violence order, but has not yet been convicted of any related criminal offense. What is the most appropriate and legally compliant course of action regarding their license? Option A. Only report the domestic violence order if specifically asked about it by the registrar during a routine license renewal process. Option B. Immediately notify the Registrar of Firearms in Tasmania of the domestic violence order, as this constitutes a significant change in personal circumstances that may affect suitability for a license. Option C. Wait to report the domestic violence order until such time as a formal inquiry or review of the license is initiated by the registrar. Option D. Assume the license will remain unaffected as long as no criminal conviction arises from the domestic violence order. The correct answer is B. Immediately notify the Registrar of Firearms in Tasmania of the domestic violence order, as this constitutes a significant change in personal circumstances that may affect suitability for a license. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent risks associated with firearms and the strict legal framework governing their possession and use in Tasmania. A licensee must demonstrate ongoing suitability and adherence to legislative requirements. Failure to do so can have severe consequences, including license suspension or cancellation, and potential legal penalties. The challenge lies in accurately assessing and reporting changes in personal circumstances that might impact suitability for a Category H firearms license under the Tasmanian Firearms Act 1996. Correct approach analysis. The best professional practice involves proactively and truthfully informing the Registrar of Firearms in Tasmania of any significant change in personal circumstances that could affect suitability for a Category H license. This approach directly aligns with the obligations under Section 18 of the Tasmanian Firearms Act 1996, which mandates that a licensee must notify the registrar of any prescribed changes in their circumstances. This includes, but is not limited to, changes in residential address, and any event that might render them a prohibited person or otherwise unsuitable to hold a firearms license. Prompt and honest disclosure ensures compliance, maintains the integrity of the licensing system, and demonstrates the licensee's commitment to responsible firearm ownership. Incorrect approaches analysis. Failing to report a domestic violence order, even if it is not a criminal conviction, is a significant regulatory failure. The Tasmanian Firearms Act 1996, particularly in conjunction with relevant family violence legislation, considers such orders as indicators of potential risk and a factor in assessing a person's suitability to possess firearms. Notifying the registrar is a legal requirement, and failure to do so constitutes a breach of the Act, potentially leading to license cancellation and penalties. Delaying notification until a formal inquiry or review is initiated is also professionally unacceptable. While the Act requires notification of prescribed changes, waiting for external pressure undermines the spirit of responsible firearm ownership and the proactive nature of the regulatory framework. It suggests a lack of commitment to transparency and may be interpreted as an attempt to conceal information, which is ethically unsound and legally risky. Assuming that domestic violence order will not affect the license because it is not a criminal conviction is a dangerous misinterpretation of the law. The suitability provisions under the Tasmanian Firearms Act 1996 are broader than just criminal convictions and encompass factors that indicate a risk to public safety or the licensee's own safety. A domestic violence order is a clear indicator that such a risk may exist, and the registrar has a duty to assess this. Professional reasoning. Professionals in this situation must adopt a proactive and transparent approach. The decision-making process should involve 1. Understanding the legal obligations. Familiarize oneself with the specific requirements of the Tasmanian Firearms Act 1996 and any associated regulations regarding notification of changes in circumstances. 2. Assessing the impact of the change. Evaluate how the new circumstance, e.g., a domestic violence order, might be perceived by the registrar in relation to the criteria for holding a firearms license. 3. Prioritizing compliance and safety. Recognize that the primary objective of firearms legislation is public safety and responsible ownership. 4. Acting promptly and honestly. If a change in circumstances occurs that is prescribed or could reasonably be considered to affect suitability, immediate notification to the registrar is the only compliant and ethical course of action. 5. Seeking clarification if unsure. If there is any doubt about whether a circumstance needs to be reported, it is always best to err on the side of caution and contact the registrar for clarification. Question 8. Consider a scenario where a licensed firearms dealer in Tasmania is presented with an application for a Category H firearm. The applicant has a valid Category H license and states their intended purpose for acquiring the firearm is for sporting purposes. What is the most appropriate course of action for the dealer to ensure compliance with Tasmanian firearms regulations? Option A. The dealer should verify that the applicant's stated sporting purposes are consistent with the specific types of Category H firearms permitted for such use under Tasmanian law and seek any necessary documentation or confirmation of this intended use. Option B. The dealer should accept the applicant's verbal assurance of sporting purposes as sufficient, given they hold a valid Category H license. Option C. The dealer should proceed with the sale immediately, as the applicant has presented a valid Category H license and the stated purpose is broadly defined. Option D. The dealer should assume that any stated sporting purpose is automatically valid for any Category H firearm, as the license itself signifies eligibility. The correct answer is A. The dealer should verify that the applicant's stated sporting purposes are consistent with the specific types of Category H firearms permitted for such use under Tasmanian law and seek any necessary documentation or confirmation of this intended use. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a firearms dealer in Tasmania to navigate the specific requirements for a Category H firearms license application, particularly concerning the applicant's stated purpose for acquiring the firearm. Misinterpreting or failing to adhere to the Tasmanian Firearms Act 1996 and its associated regulations can lead to serious legal consequences, including penalties for supplying firearms to unlicensed individuals or for failing to conduct due diligence. The dealer must balance facilitating legitimate firearm ownership with their strict legal obligations to prevent misuse and ensure public safety. Correct approach analysis. The best professional practice involves the firearms dealer meticulously verifying that the applicant's stated purpose for acquiring the Category H firearm aligns with the genuine reasons permitted under Tasmanian law for such a license. This means actively seeking evidence or confirmation that the applicant's intended use, e.g., competitive shooting, collecting, or specific occupational requirements as defined by the Act, is legitimate and documented. The dealer must ensure the applicant possesses the correct license category for their intended purpose and that all application requirements are met before proceeding with the sale or transfer. This approach is correct because it directly upholds the spirit and letter of the Tasmanian Firearms Act 1996, which mandates that firearms are acquired for lawful purposes and that license holders meet specific criteria for their intended use. Incorrect approaches analysis. One incorrect approach involves the dealer accepting the applicant's verbal assurance of their intended use without seeking any corroborating evidence or verifying its legitimacy against the requirements for Category H license. This fails to meet the dealer's due diligence obligations under Tasmanian law, which requires more than mere self-declaration. It risks facilitating the acquisition of a firearm for an unverified or potentially unlawful purpose. Another incorrect approach is for the dealer to assume that because the applicant has a Category H license, any stated purpose is automatically valid. While the license indicates eligibility, the specific purpose for acquiring a particular firearm must still be consistent with the license conditions and the Act. This approach neglects the dealer's responsibility to ensure the specific transaction aligns with legal requirements. A further incorrect approach is for the dealer to proceed with the sale based solely on the applicant presenting a valid Category H license, without confirming if the specific firearm being purchased is appropriate for the stated purpose, or if any additional endorsements or conditions apply. This overlooks the nuanced requirements that may exist for certain types of Category H firearms or specific usage scenarios under Tasmanian legislation. Professional reasoning. Professionals in this field must adopt a proactive and diligent approach. This involves understanding the specific legislative framework, Tasmanian Firearms Act 1996, being aware of the different firearm categories and their associated license requirements, and implementing robust internal procedures for verifying applicant information and intended use. When faced with ambiguity or a potentially problematic situation, the professional should err on the side of caution, seek clarification from the applicant, and, if necessary, consult with the relevant licensing authorities in Tasmania before proceeding. The primary ethical and legal duty is to ensure compliance and public safety. Question 9. During the evaluation of an application for Category H firearms license in Tasmania, what is the most appropriate method for the applicant to demonstrate a genuine reason for possessing such a firearm, in accordance with the Firearms Act 1996 TAS? Option A. Presenting a collection of newspaper clippings about firearms and a letter from a friend attesting to the applicant's responsible character. Option B. Providing official documentation from an approved shooting club confirming membership and participation in regulated shooting activities relevant to Category H firearms, alongside a clear statement of the specific sporting or recreational purpose. Option C. Including a membership card for a general hunting club that does not specifically cater to or recognize Category H firearms. Option D. Submitting a general statement expressing an interest in firearms and self-defense, without specific details of any organized shooting activities. The correct answer is B. Providing official documentation from an approved shooting club confirming membership and participation in regulated shooting activities relevant to Category H firearms, alongside a clear statement of the specific sporting or recreational purpose. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for a Category H firearms license in Tasmania, which involves demonstrating a genuine reason for possessing such a firearm and ensuring all documentation is compliant with the Firearms Act 1996, TAS, and its associated regulations. The complexity arises from the need to accurately interpret and apply these legal provisions to a personal circumstance, ensuring no misrepresentation or omission occurs. Failure to do so can lead to license refusal, potential legal repercussions, and a negative impact on future applications. Correct approach analysis. The best professional practice involves the applicant meticulously reviewing the Tasmanian Firearms Act 1996 and the relevant regulations pertaining to Category H firearms. This includes understanding the definition of genuine reason, as stipulated by the Act, which for Category H firearms typically relates to specific sporting or recreational shooting activities that are officially recognized and regulated. The applicant should gather all supporting documentation that directly substantiates their stated genuine reason, such as membership in an approved shooting club, competition results, or evidence of participation in regulated shooting events. This approach ensures full compliance with the legal framework, demonstrates a clear and verifiable genuine reason, and presents a complete and accurate application, thereby maximizing the likelihood of approval. Incorrect approach is analysis. Submitting an application with a vague or unsubstantiated reason, such as general interest in firearms without specific sporting or recreational context, fails to meet the genuine reason requirement under the Tasmanian legislation. This approach is ethically and legally deficient, as it does not provide the necessary evidence for the Registrar of Firearms to be satisfied of the applicant's legitimate purpose. Providing documentation that is outdated or does not directly support the stated genuine reason for a Category H license. For example, using a membership certificate from a club that does not cater to the specific type of shooting relevant to Category H constitutes a failure to comply with the evidentiary requirements. This misleads the licensing authority and demonstrates a lack of diligence in fulfilling application obligations. Relying on anecdotal advice from friends or online forums without cross-referencing with the official Tasmanian legislation and guidelines is a significant regulatory failure. Such information may be inaccurate, outdated, or not specific to Category H licenses, leading to an incomplete or non-compliant application. This approach prioritizes informal information over legal mandates, risking rejection and potential penalties. Professional reasoning. Professionals dealing with firearms licensing applications in Tasmania should adopt a systematic approach. This involves 1. Thoroughly understanding the specific requirements of the Firearms Act 1996, TAS, and associated regulations for the license category sought. 2. Identifying and gathering all legally mandated documentation that directly and unequivocally supports the applicant's stated genuine reason. 3. Ensuring all information provided is accurate, current, and verifiable. 4. Seeking clarification from the relevant Tasmanian authorities if any aspect of the legislation or application process is unclear. This methodical and legally grounded approach ensures integrity and compliance. Question 10. Research into the requirements for Category H firearms license in Tasmania reveals that applicants must declare the maximum number of Category H firearms their proposed storage safe can accommodate. Mr. Smith has a safe with internal dimensions of 150 cm height, x 75 cm width, x 60 cm depth. He intends to store Category H firearms, each requiring a minimum of 120 cm height, x 20 cm width, x 15 cm depth of space when stored upright and unloaded, with a standard rifle rack configuration. Assuming each firearm is stored individually and does not overlap, what is the maximum number of Category H firearms Mr. Smith can legally declare his safe can accommodate, according to Tasmanian regulations? Option A, 6. Option B, 3. Option C, 4. Option D, 5. The correct answer is B, 3. Explanation. This scenario is professionally challenging because it requires the applicant to accurately calculate and declare their firearm storage capacity in accordance with Tasmanian regulations, specifically the Firearms Act 1996 (TAS) and associated regulations. Misrepresenting storage capacity can lead to serious legal consequences, including license refusal or cancellation, and potential criminal charges. The applicant must understand the specific requirements for storing Category H firearms, which often have stricter rules due to their classification. The best professional approach involves a precise calculation of the maximum number of Category H firearms that can be legally stored in the proposed safe, considering the safe's dimensions and any specific Tasmanian regulations regarding firearm storage density or configuration. This approach ensures full compliance with the Firearms Act 1996 (TAS) and its regulations, which mandate accurate declaration of storage capacity. By meticulously measuring and calculating, the applicant demonstrates due diligence and a commitment to lawful firearm ownership, thereby satisfying the requirements for a Category H license. An incorrect approach would be to estimate the storage capacity based on a general understanding of safes, or to assume that a safe of a certain size can hold a specific number of firearms without precise measurement and calculation. This fails to meet the regulatory requirement for accuracy and could lead to an overdeclaration of storage capacity, which is a contravention of the Firearms Act 1996 (TAS). Another incorrect approach is to only consider the number of firearms currently owned, rather than the maximum capacity of the safe. The license application requires declaration of the safe's capacity, not just current holdings, to ensure future compliance. Finally, an approach that involves rounding up the number of firearms to appear as if the safe has more capacity than it actually does is a deliberate misrepresentation and a serious breach of regulatory requirements and ethical conduct. Professionals should use a decision-making framework that prioritizes accuracy and regulatory adherence. This involves understanding the specific legal requirements of the jurisdiction, Tasmania, meticulously gathering all necessary data, safe dimensions, firearm dimensions if relevant to configuration, performing precise calculations, and accurately declaring the information. If there is any doubt about the calculation or interpretation of regulations, seeking clarification from the Tasmanian Firearms Registry or a legal professional is paramount. Question 11. Governance review demonstrates that a firearms dealer in Tasmania has been presented with a firearms license by a prospective buyer that appears to be valid, but the expiry date has passed. The buyer states they are in the process of renewing it and will have the new license shortly. What is the most appropriate course of action for the dealer to take to ensure regulatory compliance? Option A. Process the sale using the expired license and note in the dealer's records that renewal is pending. Option B. Advise the buyer to return with the renewed license before any sale can be considered. Option C. Accept the expired license as proof of the buyer's intent to renew and proceed with the sale pending receipt of the new license. Option D. Immediately contact the Tasmania Police Firearms Registry to verify the current status of the buyer's firearms license. The correct answer is D. Immediately contact the Tasmania Police Firearms Registry to verify the current status of the buyer's firearms license. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in Tasmania due to the stringent regulatory environment surrounding firearms licensing and the ethical obligation to prevent prohibited persons from acquiring firearms. The dealer must navigate the legal requirements for verifying license validity, while also upholding public safety. The challenge lies in balancing efficient business operations with the critical need for due diligence, especially when presented with potentially expired or invalid documentation. Correct approach analysis. The best professional practice involves immediately verifying the validity of the license with the Tasmania Police Firearms Registry. This approach is correct because Section 32 of the Firearms Act 1996, (TAS), mandates that a dealer must not sell or transfer a firearm to a person unless that person produces a valid firearms license. The Act further implies a duty of care to ensure the license presented is currently valid. Direct verification with the registry is the most reliable method to confirm the license's status, thereby ensuring compliance with the law and preventing the illegal sale of a firearm. This proactive step mitigates risk for the dealer and upholds public safety. Incorrect approaches analysis. Presenting an expired license for a firearm purchase is a direct contravention of Section 32 of the Firearms Act 1996, TAS. The dealer has a legal obligation to ensure the license is valid at the time of sale. Accepting an expired license, even with the promise of renewal, constitutes a failure to comply with the Act and could lead to severe penalties, including license suspension or cancellation, and potential criminal charges. Assuming the license is valid because it appears legitimate and the customer claims it is current without independent verification is a failure of due diligence. While the license may look authentic, its validity is determined by the registry. Relying solely on the physical appearance of the license or the customer's word bypasses the legal requirement for confirmation and exposes the dealer to significant legal and ethical risks. This approach prioritizes convenience over compliance, suggesting the customer can simply renew their license after the purchase, and that the dealer will accept the expired license as proof of intent to renew, is an unacceptable circumvention of the law. The Firearms Act 1996, TAS, requires a valid license at the point of sale. Post-purchase renewal does not retroactively validate the transaction. This approach demonstrates a disregard for the regulatory framework and a willingness to engage in potentially illegal activity, severely compromising professional integrity and public safety. Professional reasoning. Professionals in regulated industries like firearms dealing must adopt a proactive and compliance-first mindset, and faced with any ambiguity or potential noncompliance, the decision-making process should involve 1. Identifying the relevant legal and regulatory requirements, e.g., Firearms Act 1996 TAS. 2. Assessing the specific situation against these requirements. 3. Prioritizing verification and confirmation over assumptions or convenience. 4. Consulting with regulatory bodies or legal counsel if uncertainty persists. The paramount consideration must always be adherence to the law and the safeguarding of public safety. Question 12. Strategic planning requires an applicant for a Category H firearms license in Tasmania to meticulously prepare their application. Considering the specific provisions of the Tasmanian Firearms Act 1996, which of the following approaches best ensures compliance and a successful outcome? Option A. Submitting a comprehensive dossier of personal and professional history, assuming that more information will demonstrate greater suitability for a Category H license. Option B. Thoroughly reviewing the Tasmanian Firearms Act 1996 and its associated regulations to identify all specific documentation and criteria for a Category H license, and submitting only that precisely required information. Option C. Relying on general firearm licensing advice and assuming that the requirements for a Category H license in Tasmania are similar to those for other firearm categories. Option D. Providing a detailed personal narrative about the applicant's passion for firearms, without necessarily attaching specific documentary evidence of a genuine reason as defined by the Act. The correct answer is B. Thoroughly reviewing the Tasmanian Firearms Act 1996 and its associated regulations to identify all specific documentation and criteria for a Category H license, and submitting only that precisely required information. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements of the Tasmanian Firearms Act 1996 and its associated regulations concerning the Category H firearms license. The challenge lies in accurately identifying and presenting the necessary documentation and information to satisfy the licensing authority, particularly when dealing with the nuances of demonstrating genuine reason and suitability. Failure to adhere strictly to these requirements can lead to delays, rejection of the application, or even potential penalties. Careful judgment is required to ensure all legal obligations are met without oversharing or providing irrelevant information. Correct approach analysis. The best professional practice involves a thorough review of the Tasmanian Firearms Act 1996 and the relevant regulations pertaining to Category H licenses. This includes understanding the specific criteria for demonstrating a genuine reason for possessing such a firearm, which for Category H often relates to specific sporting or collecting purposes as defined by the Act. The applicant must then meticulously gather and present only the documentation explicitly required by the Act and the application form, such as proof of identity, evidence of genuine reason e.g., club membership, competition results, and any other stipulated requirements. This approach ensures compliance with legal obligations, avoids unnecessary disclosure of personal information, and presents a clear, defensible case to the licensing authority. Incorrect approach is analysis. One incorrect approach is to assume that general firearm ownership requirements are sufficient for a Category H license. This fails to acknowledge the specific, often more stringent, criteria for this category under Tasmanian law, potentially leading to an incomplete application and rejection. Another incorrect approach is to provide extensive personal information beyond what is explicitly requested in the application form and mandated by the Firearms Act 1996. This not only risks overwhelming the licensing authority, but also raises privacy concerns and may be perceived as an attempt to circumvent specific requirements by offering extraneous details. A further incorrect approach is to rely solely on anecdotal advice from other firearm owners without verifying the information against the official Tasmanian legislation and licensing authority guidelines. This can lead to misunderstandings of the legal requirements and the submission of an application that does not meet the statutory obligations. Professional reasoning. Professionals should approach such applications by prioritizing a deep understanding of the governing legislation. This involves consulting the primary source documents, the Act and regulations, and seeking clarification from the relevant Tasmanian licensing authority when in doubt. A systematic approach of identifying each requirement, gathering the specific supporting evidence, and ensuring its accuracy and relevance is crucial. Professionals should also be mindful of their ethical obligations regarding client confidentiality and the responsible handling of personal information. Question 13. Strategic planning requires an applicant for Category H firearms license in Tasmania to consider their past, but how should they best approach the disclosure of previous mental health treatment when applying? Option A. Briefly mention having sought counseling in the past without providing specific details or supporting documentation, assuming the registrar will not investigate further. Option B. Omit any mention of past mental health treatment, believing it is a private matter and irrelevant if it occurred many years ago. Option C. Provide a detailed personal history including the nature of the treatment, the dates of treatment, and comprehensive supporting documentation from treating professionals confirming current mental health stability and fitness to possess a firearm. Option D. State that past mental health issues are resolved and provide a letter from a general practitioner confirming the applicant is generally well, without detailing the specific nature of the past treatment. The correct answer is C. Provide a detailed personal history including the nature of the treatment, the dates of treatment, and comprehensive supporting documentation from treating professionals confirming current mental health stability and fitness to possess a firearm. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements of the Tasmanian Firearms Act 1996 and associated regulations regarding the suitability of a Category H firearms license. The challenge lies in accurately interpreting and applying these provisions to a personal circumstance that may involve past behavioral issues, ensuring that the application demonstrates genuine compliance and does not mislead the registrar of firearms. A failure to be transparent and thorough can lead to license refusal, potential penalties, and a lasting negative impact on the applicant's ability to obtain a license in the future. Careful judgment is required to balance the desire for a license with the absolute necessity of meeting all legal and ethical obligations. Correct approach analysis. The best professional practice involves a comprehensive and transparent disclosure of all relevant information to the registrar of firearms. This approach requires the applicant to proactively identify and provide documentation that addresses any past issues that might be relevant to their suitability, such as evidence of rehabilitation, ongoing treatment, or a significant period of stable behavior. Specifically, this means providing a detailed personal history that includes any past convictions, apprehended violence orders, or mental health episodes, along with supporting evidence demonstrating that these issues are resolved or managed to a degree that does not compromise public safety. This aligns with the spirit and letter of the Firearms Act 1996, which mandates that the registrar must be satisfied that an applicant is a fit and proper person to hold a license, considering factors that may affect their ability to possess a firearm safely. Full disclosure ensures that the registrar has all necessary information to make an informed decision, fostering trust and demonstrating the applicant's commitment to responsible firearm ownership. Incorrect approach is analysis. One incorrect approach is to omit any mention of past mental health treatment, believing it is irrelevant or will automatically disqualify the applicant. This is a regulatory failure because the Firearms Act 1996 requires the registrar to consider any matter that may affect an applicant's suitability, and past mental health issues, even if treated, can be relevant to assessing risk. Concealing such information constitutes a breach of the duty to provide accurate and complete information, potentially leading to license refusal and future prohibitions. Another incorrect approach is to only provide a brief, vague statement about past difficulties without offering any supporting documentation or evidence of current stability. This is ethically problematic, as it fails to meet the burden of proof required to satisfy the registrar of suitability. While not explicitly lying, it is a failure to provide sufficient information, which can be interpreted as an attempt to mislead or downplay significant issues, thereby undermining the integrity of the licensing process. A third incorrect approach is to assume that a significant period of time passing since the last incident automatically negates the need for disclosure. While time can be a factor in demonstrating rehabilitation, the Firearms Act 1996 does not prescribe a statute of limitations for disclosing relevant past events. Failing to disclose, even if the event occurred many years ago, is a failure to comply with the requirement for full disclosure of all matters that might be relevant to the applicant's suitability to possess a firearm. Professional reasoning. Professionals should adopt a proactive and transparent approach when applying for a firearms license, especially when there are potential concerns regarding suitability. The decision-making process should involve thoroughly reviewing the requirements of the Tasmanian Firearms Act 1996 and its regulations, identifying any personal circumstances that might be relevant, and gathering comprehensive supporting evidence. This includes seeking legal advice if necessary to understand the full implications of past events and how best to present them. The guiding principle should always be to provide the registrar with all necessary information to make an informed and safe decision, demonstrating a commitment to responsible firearm ownership and public safety. Question 14. Strategic planning requires an applicant for Category H firearms license in Tasmania to demonstrate a genuine reason for possessing such a firearm. Which of the following approaches best ensures compliance with the Tasmanian Firearms Act 1996 and its regulations when preparing an application? Option A. Providing detailed evidence of membership in an approved shooting club, participation in club events, and documentation supporting the specific sporting discipline for which the Category H firearm is intended. Option B. Stating a general interest in firearms and a desire to own a Category H firearm for personal collection purposes. Option C. Focusing on the applicant's perceived need for self-defense as the primary justification for the license. Option D. Submitting a letter from a friend indicating they have seen the applicant shoot safely on private property. The correct answer is A. Providing detailed evidence of membership in an approved shooting club, participation in club events, and documentation supporting the specific sporting discipline for which the Category H firearm is intended. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements of the Tasmanian Firearms Act 1996 and associated regulations concerning the Category H firearms license. The challenge lies in accurately identifying and demonstrating compliance with all necessary criteria, particularly those related to genuine reason and suitability, which are subject to interpretation and require thorough documentation. Failure to do so can result in license refusal, impacting the applicant's lawful ability to possess and use firearms for their stated purpose. Correct approach analysis. The best professional approach involves meticulously gathering and presenting all documentation that directly supports the applicant's stated genuine reason for a Category H license, as defined by Tasmanian law. This includes providing evidence of membership in an approved club or association, proof of participation in relevant shooting activities, and any other documentation that substantiates the lawful and safe use of Category H firearms for that specific purpose. This approach is correct because it directly addresses the core requirement of the Firearms Act 1996, which mandates that an applicant must demonstrate a genuine reason for possessing such a firearm. It also aligns with the principles of regulatory compliance, by providing verifiable evidence to the Registrar of Firearms. Incorrect approach is analysis. One incorrect approach is to assume that simply stating a desire to own a Category H firearm for sport is sufficient without providing concrete evidence. This fails to meet the statutory requirement of demonstrating a genuine reason as defined by the Act, which necessitates more than a mere assertion. It overlooks the need for verifiable proof of participation and legitimate use. Another incorrect approach is to focus solely on personal safety as the primary reason for Category H license, without understanding that Tasmanian law generally restricts the genuine reasons for Category H licenses to specific sporting or occupational purposes, and personal protection is typically not considered a primary genuine reason for this category of firearm. This misunderstands the specific legislative intent for Category H licenses. A further incorrect approach is to submit incomplete or outdated documentation, such as expired club memberships or irrelevant training certificates. This demonstrates a lack of diligence and an incomplete understanding of the current requirements, potentially leading to delays or refusal due to non-compliance with the registrar's expectations for up-to-date and relevant evidence. Professional reasoning. Professionals should approach license applications by thoroughly researching the specific legislative requirements of the Tasmanian Firearms Act 1996 and its regulations. They must then guide applicants in gathering comprehensive and verifiable evidence that directly addresses each criterion, particularly the genuine reason. A systematic review of all submitted documentation against the legal framework is crucial to ensure accuracy and completeness before submission, thereby maximizing the likelihood of a successful application and upholding professional integrity. Question 15. Which approach would be most compliant with the Firearms Act 1996 TAS and best practice for a licensed firearms dealer in Tasmania when selling a Category H firearm to a customer? Option A. Sell the firearm after the customer presents an expired Category H firearms license, assuming they are still authorized to purchase. Option B. Obtain and verify the customer's current Category H firearms license. Confirm it permits the specific firearm, and promptly lodge the required transfer of registration forms with the Tasmania Police Firearms Registry. Option C. Accept the customer's verbal confirmation that they possess a valid Category H firearms license and proceed with the sale, intending to complete the paperwork later. Option D. Process the sale immediately and submit the transfer of registration forms to the Tasmania Police Firearms Registry at the end of the financial year. The correct answer is B. Obtain and verify the customer's current Category H firearms license, confirm it permits the specific firearm, and promptly lodge the required transfer of registration forms with the Tasmania Police Firearms Registry. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in Tasmania due to the strict regulatory environment surrounding firearms licensing and the transfer of ownership. The core challenge lies in ensuring absolute compliance with the Firearms Act 1996, TAS, and its associated regulations, particularly concerning the verification of a buyer's eligibility and the proper recording of transactions. Failure to adhere to these requirements can lead to severe penalties, including license suspension or cancellation, and criminal charges. The dealer must exercise meticulous judgment to avoid facilitating an illegal transfer, which carries significant ethical and legal ramifications. Correct approach analysis. The best professional practice involves a proactive and thorough verification process that prioritizes regulatory compliance. This approach requires the dealer to obtain and meticulously check the buyer's valid Category H firearms license, ensuring it is current and permits the specific type of firearm being purchased. Furthermore, the dealer must complete and lodge the required transfer of registration forms with the Tasmania Police Firearms Registry within the stipulated timeframe. This approach is correct because it directly aligns with the explicit requirements of the Firearms Act 1996, TAS, which mandates that firearms dealers verify a buyer's license before completing a sale and ensure proper registration of the transfer. This ensures that only legally authorized individuals acquire firearms and that all transactions are transparently recorded, upholding public safety and the integrity of the firearms regulatory system in Tasmania. Incorrect approach is analysis. One incorrect approach involves proceeding with the sale based solely on the buyer's verbal assurance of possessing a license, without physically inspecting the document. This is a significant regulatory failure, as it bypasses the mandatory verification step stipulated by the Firearms Act 1996, TAS, potentially leading to the sale of a firearm to an unlicensed or ineligible individual. Another incorrect approach is to delay the submission of the transfer of registration forms to the Tasmania Police Firearms Registry, perhaps due to administrative oversight or convenience. This constitutes a breach of the Act's reporting requirements and undermines the registry's ability to maintain accurate records, which is crucial for law enforcement and public safety. A third incorrect approach is to accept an expired or invalid license as sufficient proof of eligibility. This is a direct contravention of the licensing provisions of the Act, as only a current and valid license authorizes the possession and acquisition of firearms. Professional reasoning. Professionals in this field should adopt a decision-making framework that centers on a compliance-first mindset. This involves understanding that regulatory obligations are not merely procedural hurdles but fundamental safeguards. When faced with a transaction, the professional should systematically 1. Identify all applicable legal requirements, e.g., Firearms Act 1996, TAS, relevant regulations. 2. Verify all necessary documentation and information provided by the client against these legal requirements. 3. Document the verification process thoroughly. 4. Adhere strictly to all stipulated timelines for reporting and lodgment. 5. Seek clarification from regulatory authorities if any ambiguity exists. This systematic approach ensures that all legal and ethical obligations are met, thereby protecting both the business and the community. Question 16. Investigation of a Category H firearms license holder in Tasmania reveals that they store their firearm unloaded in a purpose-built locked safe. However, the ammunition is kept in a separate locked container within the same safe. Considering the regulatory framework of Tasmania, what is the most appropriate assessment of this storage practice? Option A. Storage is compliant as the firearm is in a locked safe and the ammunition is in a separate locked box. Option B. The firearm and ammunition are stored in compliance with Tasmanian regulations as both are secured. Option C. The firearm is stored appropriately, but the ammunition storage is not fully compliant as it is not stored separately from the firearm's immediate vicinity. Option D. The firearm is stored in a compliant manner, but the ammunition should be stored in a different location entirely, not within the same safe. The correct answer is B. The firearm and ammunition are stored in compliance with Tasmanian regulations, as both are secured. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the licensee to navigate the complex and specific requirements of the Tasmanian Firearms Act 1996 and its associated regulations concerning the storage and security of Category H firearms. Failure to comply can lead to severe penalties, including license suspension or cancellation, and significant legal repercussions. The licensee must demonstrate a thorough understanding of their obligations beyond mere possession, focusing on proactive measures to prevent unauthorized access and potential misuse. Correct approach analysis. The best professional practice involves proactively and demonstrably complying with the storage requirements mandated by the Tasmanian Firearms Act 1996 and the Firearms Regulations 2016. This means ensuring that the Category H firearm is stored in a locked, purpose-built safe that meets the specified security standards, and that ammunition is stored separately and securely, also in a locked container. The licensee must be able to produce evidence of this compliance, such as purchase receipts for the safe, and be prepared to demonstrate its functionality and adherence to the regulations during any inspection. This approach directly addresses the legislative intent of preventing unauthorized access and is the most robust defense against potential breaches. Incorrect approaches analysis. Storing the firearm in a locked cabinet that is not specifically designed or certified for Category H firearms, and keeping ammunition in the same cabinet, fails to meet the stringent security requirements outlined in the Tasmanian legislation. The law specifies particular standards for the construction and locking mechanisms of safes for Category H firearms, and the separate storage of ammunition is a critical safety measure to prevent immediate use in the event of a security breach. This approach risks noncompliance due to inadequate security provisions, leaving the firearm unloaded in a locked drawer within the home, with ammunition stored in a separate locked box elsewhere in the house, while better than no security, still falls short of the legislative requirements for Category H firearms. The Tasmanian Firearms Act 1996 mandates the use of a purpose-built, securely locked safe for these categories of firearms, not a general-purpose drawer. While ammunition is stored separately, the primary storage of the firearm itself is not compliant. Storing the firearm unloaded in a locked safe, but keeping the ammunition readily accessible in the same safe, presents a significant safety and regulatory failure. The Tasmanian Firearms Regulations 2016 explicitly require ammunition to be stored separately from the firearm, even when both are secured. This is a fundamental safety principle designed to mitigate risk, and failing to adhere to it constitutes a direct breach of the regulations. Professional reasoning. Professionals in Tasmania holding a Category H firearms license must adopt a proactive and meticulous approach to compliance. The decision-making process should center on a thorough understanding of the specific legislative requirements of the Tasmanian Firearms Act 1996 and the Firearms Regulations 2016. This involves not just knowing the rules, but actively implementing and maintaining practices that demonstrably meet or exceed those standards. When in doubt about specific storage requirements, licensees should consult the relevant legislation directly or seek advice from the Tasmania Police Firearms Services. Prioritizing regulatory adherence and safety over convenience is paramount. Question 17. Assessment of a firearms dealer's responsibilities in Tasmania when processing a Category H firearms license renewal for a client who claims their license is still valid and eligible for renewal. What is the most compliant and professionally sound course of action? Option A. Process the renewal based on the applicant providing a copy of their expired Category H license, assuming no changes have occurred. Option B. Contact the Tasmanian Police Firearms Registry to verify the applicant's current eligibility for a Category H license prior to processing the renewal. Option C. Assume that previous eligibility automatically guarantees renewal eligibility for Category H license. Option D. Accept the applicant's statement that their license is eligible for renewal and proceed with the paperwork based on their assurance. The correct answer is B. Contact the Tasmanian Police Firearms Registry to verify the applicant's current eligibility for a Category H license prior to processing the renewal. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in Tasmania regarding the renewal of a Category H firearms license. The challenge lies in ensuring compliance with the specific requirements of the Tasmanian Firearms Act 1996 and its associated regulations, particularly concerning the verification of continued eligibility for a Category H license. Failure to adhere to these regulations can result in significant penalties, including license suspension or cancellation, and potential criminal charges. The dealer must exercise careful judgment to balance business operations with strict legal obligations. Correct approach analysis. The best professional practice involves proactively verifying the applicant's continued eligibility for a Category H license by directly consulting the Tasmanian Police Firearms Registry. This approach ensures that the dealer is acting on current and accurate information as mandated by the Firearms Act 1996. Specifically, Section 38 of the Act outlines the requirements for license renewal, which includes the applicant continuing to satisfy the eligibility criteria. By contacting the registry, the dealer confirms that the applicant still meets these criteria, such as demonstrating a genuine reason for possessing a Category H firearm and not posing a risk to public safety, as assessed by the registrar. This proactive verification is crucial for lawful and responsible firearm dealings. Incorrect approaches analysis. One incorrect approach involves simply accepting the applicant's verbal assurance that their license is eligible for renewal without independent verification. This fails to meet the dealer's obligation under the Firearms Act 1996 to ensure that all transactions are conducted in accordance with the law. Relying solely on the applicant's word bypasses the necessary checks that the registrar is empowered to conduct and that a dealer must facilitate for renewals. Another incorrect approach is to assume that because the applicant has held a Category H license previously, they automatically qualify for renewal. The Firearms Act 1996 requires a reassessment of eligibility at the time of renewal. Circumstances can change, and the applicant may no longer meet the criteria, such as a change in their genuine reason or a new assessment of their suitability by the registrar. A further incorrect approach is to proceed with the renewal process based on outdated documentation or a previous license application, without confirming current eligibility with the Tasmanian Police Firearms Registry. The Act mandates that the registrar must be satisfied that the applicant continues to meet the requirements for the license category at the time of renewal. Professional reasoning. Professionals in this field must adopt a systematic approach to license renewals. This involves understanding the specific legislative requirements of Tasmania, particularly the Firearms Act 1996 and its regulations. When faced with a license renewal, the primary step should always be to confirm current eligibility with the relevant authority. In this case, the Tasmanian Police Firearms Registry. This proactive verification process mitigates risk, ensures compliance, and upholds the integrity of the firearms licensing system. Professionals should maintain clear records of all verifications and communications with authorities. Question 18. Strategic planning requires a firearms dealer in Tasmania to anticipate potential compliance challenges. If a customer presents a Category H firearms license for the purchase of a specific handgun, what is the most prudent and legally compliant course of action for the dealer to ensure adherence to the Firearms Act 1996, Tasmania? Option A. Accept the customer's expired Category H firearms license as sufficient proof of their entitlement to purchase the handgun. Option B. Verify the current validity and suitability of the customer's Category H firearms license for the specific handgun being purchased through official channels. Option C. Proceed with the sale based on the customer's verbal assurance that their license is current and valid. Option D. Rely on the customer's history of previous purchases from the dealership as confirmation of their current license status. The correct answer is B. Verify the current validity and suitability of the customer's Category H firearms license for the specific handgun being purchased through official channels. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in Tasmania due to the strict regulatory environment surrounding firearms licensing and the transfer of ownership. The dealer must navigate the legal requirements to ensure compliance, prevent illegal acquisition of firearms, and maintain their license. Failure to do so can result in severe penalties, including license suspension or cancellation, and criminal charges. The core challenge lies in balancing efficient business operations with the absolute imperative of adhering to the Firearms Act 1996, Tasmania, and its associated regulations. Correct approach analysis. The best professional practice involves proactively verifying the validity and appropriateness of the customer's Category H firearms license before proceeding with any sale or transfer. This means not just visually inspecting the license, but also confirming its current status and ensuring it permits the specific type of firearm being purchased. This approach aligns directly with the obligations of a firearms dealer under the Firearms Act 1996, Tasmania, specifically sections pertaining to the sale and transfer of firearms, which mandate that dealers must be satisfied that the purchaser is lawfully entitled to possess the firearm. This proactive verification is the cornerstone of responsible firearms dealing and regulatory compliance. Incorrect approaches analysis. Proceeding with the sale based solely on the customer's assurance that they possess a valid license is a significant regulatory failure. The Firearms Act 1996, Tasmania, places the onus on the dealer to verify lawful entitlement, not to rely on the customer's word alone. This approach risks facilitating the acquisition of a firearm by an individual who may no longer hold a valid license or whose license does not cover the specific firearm. Accepting an expired license as sufficient evidence of current entitlement is also a direct contravention of the Act. Licenses have expiry dates, and possession of an expired license does not confer lawful entitlement to possess a firearm. This demonstrates a lack of diligence and a failure to understand fundamental licensing requirements. Relying on the customer's previous purchase history with the dealership as a substitute for current license verification is another critical error. Past transactions do not guarantee current legal standing. Licensing status can change, and each transaction requires independent verification of current entitlement under the law. This approach is negligent and exposes the dealer to significant legal risk. Professional reasoning. Professionals in this field must adopt a risk-based approach to compliance. This involves understanding the specific legal obligations imposed by the Firearms Act 1996, Tasmania, and implementing robust internal procedures to meet those obligations. When faced with a transaction, the decision-making process should always begin with a thorough verification of the customer's license against the requirements for the specific firearm. If any doubt exists, or if verification is not possible, the transaction should be postponed or refused until full compliance can be assured. This prioritizes legal and ethical responsibilities over immediate commercial gain. Question 19. Risk assessment procedures indicate that a firearms dealer in Tasmania, processing an application for a Category H firearms license, has received an application from an individual who has declared a past minor conviction for assault that occurred over 10 years ago. The applicant states they have had no further issues with the law since. What is the most appropriate course of action for the dealer to ensure compliance with the Firearms Act 1996 (TAS) and the Firearms Regulations 2016 (TAS)? Option A. Immediately reject the application based on the declared conviction for assault, as any history of violence is inherently disqualifying for a Category H firearms license in Tasmania. Option B. Accept the applicant's statement at face value and proceed with processing the application, assuming that conviction over 10 years ago is unlikely to be a disqualifying factor for a Category H license. Option C. Advise the applicant to obtain a statutory declaration from a former employer stating they were a reliable employee, and if this is provided, proceed with the application without further verification of the conviction's relevance. Option D. Conduct a thorough review of the applicant's submitted documentation, cross-referencing their declared history with the specific disqualifying criteria for Category H licenses under Tasmanian law, and if any ambiguity remains, seek further information from the applicant or refer the matter to the Commissioner of Police for assessment. The correct answer is D. Conduct a thorough review of the applicant's submitted documentation, cross-referencing their declared history with the specific disqualifying criteria for Category H licenses under Tasmanian law, and if any ambiguity remains, seek further information from the applicant or refer the matter to the Commissioner of Police for assessment. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in Tasmania by requiring them to balance their legal obligations under the Firearms Act 1996 (TAS) and associated regulations with the need to conduct business efficiently. The core challenge lies in accurately assessing the suitability of a prospective Category H firearms license holder, particularly when the applicant has a history that might raise concerns, without unfairly prejudicing them or contravening licensing requirements. Careful judgment is required to ensure compliance while maintaining a fair and thorough process. Correct approach analysis. The best professional practice involves a comprehensive review of the applicant's documentation, including their completed application form and any supporting evidence provided, and cross-referencing this with the requirements stipulated in the Firearms Act 1996 (TAS) and the Firearms Regulations 2016 (TAS) regarding Category H licenses. This includes verifying identity, ensuring the applicant meets the age and residency requirements, and critically assessing whether any declared circumstances, such as past convictions or mental health history, would disqualify them under the Act. If any doubt or ambiguity arises, the dealer must proactively seek clarification from the applicant or, if necessary, refer the matter to the Commissioner of Police for further assessment as per their statutory obligations. This approach ensures all legal prerequisites are met and that the dealer acts as a responsible gatekeeper, upholding public safety and the integrity of the licensing system. Incorrect approaches analysis. One incorrect approach is to proceed with the application solely based on the applicant's assertion that they have no disqualifying factors, without independently verifying the information against the legislative requirements for a Category H license. This fails to meet the dealer's duty of care and statutory obligation to ensure the applicant is a fit and proper person, potentially leading to the issuance of a license to an unsuitable individual. Another incorrect approach is to dismiss the application outright based on a single piece of information that might be misinterpreted or is not a definitive disqualifier under Tasmanian law, without allowing the applicant the opportunity to provide context or further evidence. This could be discriminatory and contravenes the principle of due process. A further incorrect approach is to rely on informal advice or hearsay regarding the applicant's suitability, rather than adhering strictly to the documented procedures and legal criteria outlined in the Firearms Act 1996, TAS, and its regulations. This introduces an unacceptable level of subjectivity and risk into the assessment process. Professional reasoning. Professionals in Tasmania dealing with firearms licensing must adopt a systematic and evidence-based approach. This involves understanding the specific requirements of the Firearms Act 1996 TAS and the Firearms Regulations 2016 TAS for each license category. When assessing an applicant, they should follow a clear checklist derived from these regulations, document all steps taken, and maintain a record of all communications and decisions. Any concerns or ambiguities should be addressed through formal channels, escalating to the relevant authorities when necessary, rather than making assumptions or relying on informal assessments. This ensures both legal compliance and ethical conduct. Question 20. The evaluation methodology shows that a Tasmanian resident is applying for Category H firearms license for pest control on their 500-hectare rural property. The applicant estimates they need to control an average of 150 rabbits, 50 foxes, and 20 feral pigs per year. The property has varied terrain, with some areas requiring shots up to 200 meters. The applicant has held a firearms license for 10 years without incident. Considering the requirements of the Firearms Act 1996 TAS, which of the following approaches best justifies the applicant's need for a Category H license? Option A. Prioritize the applicant's convenience by approving the Category H license based on their assertion of significant pest problems to avoid lengthy delays in processing. Option B. Focus on the applicant's 10 years of safe firearm handling with a Category A license, assuming this experience inherently qualifies them for a Category H license for pest control. Option C. Accept the applicant's stated pest numbers and their previous Category A license history as sufficient evidence of a genuine need for a Category H firearm. Option D. Calculate the estimated ammunition expenditure required to address the stated pest numbers at the maximum proposed engagement distance, and assess the potential for safe and effective pest control within the property boundaries. Correct answer is D. Calculate the estimated ammunition expenditure required to address the stated pest numbers at the maximum proposed engagement distance, and assess the potential for safe and effective pest control within the property boundaries. Explanation. This scenario is professionally challenging because it requires a firearms license applicant to demonstrate a clear and present need for a Category H firearm, which involves a higher degree of risk. The applicant's stated reason for needing a firearm for pest control on a large rural property, while seemingly legitimate, must be rigorously assessed against the specific requirements of Tasmanian law, particularly the Firearms Act 1996, TAS, and associated regulations. The challenge lies in quantifying the risk and ensuring the applicant's proposed use aligns with lawful and safe practices, avoiding any misinterpretation or overreach of the license conditions. The best approach involves a detailed, quantitative risk assessment that directly addresses the applicant's stated need for a Category H firearm for pest control. This includes calculating the estimated number of pest animals requiring control over a defined period, the typical distances involved in such control, and the potential for collateral damage or unintended consequences. This approach is correct because it aligns with the principle of demonstrating a genuine and specific need, as required by the Firearms Act 1996 TAS. Specifically, Section 37 of the Act mandates that an applicant must satisfy the Commissioner of Police that they have a genuine reason for possessing a firearm. For pest control, this genuine reason must be demonstrably significant and necessitate the use of a Category H firearm, rather than a less restricted category. A quantitative assessment provides objective evidence to support this claim, allowing for a robust and defensible decision. It also implicitly considers the safety aspects by evaluating the context of use, which is paramount for license approval. An approach that relies solely on the applicant's assertion of significant pest problems, without further quantification, is professionally unacceptable. This fails to meet the evidentiary burden required by Section 37 of the Firearms Act 1996, TAS, which demands more than a mere statement of need. It risks approving a license based on subjective claims rather than objective evidence, potentially leading to the misuse of firearms or increased risk to public safety. Another professionally unacceptable approach is to focus exclusively on the applicant's experience with firearms without adequately assessing the specific need for a Category H firearm for pest control. While experience is a factor in safe handling, it does not, in itself, establish a genuine reason for possessing a particular category of firearm. The law requires a demonstrable need for the type of firearm requested, not just the ability to use one. Finally, an approach that prioritizes the convenience of the applicant over a thorough risk assessment is also unacceptable. While it is important to process applications efficiently, the paramount consideration must be public safety and adherence to the Firearms Act 1996 (TAS). Circumventing the detailed assessment process to expedite approval would be a serious regulatory and ethical failure. The professional reasoning process for such situations should involve a structured risk assessment framework. This framework should begin with clearly identifying the applicant's stated need and the specific firearm category requested. It should then involve gathering objective evidence to support or refute this need, including quantitative data where possible. This evidence should be weighed against the requirements of the Firearms Act 1996 (TAS) and relevant regulations, with a strong emphasis on public safety and the prevention of misuse. Finally, a clear, documented decision should be made based on this comprehensive assessment.